Hello everyone, I am Anuj Nakade and you're watching LiveLaw. In this video, we bring you a story from the Supreme Court where the court disciplined a sessions judge for not following the Supreme Court's directions in granting bail. As you know, bail is a very important right of a person accused of a crime. In some ways, it is a way of guaranteeing the right to liberty to a person while they are still under trial. The Supreme Court has also laid down detailed guidelines regarding arrest and bail in a case called Satyendra Kumar Until vs. Central Bureau of Investigation about 10 months ago. In this judgment, the court expressed concerns regarding a very large number of under trials languishing in our jails and issued guidelines with the sole purpose of easing the process of bail. The 2021 National Criminal Records Bureau report shows that the total number of 4,23,015 inmates were in our prisons as under trials when the data was recorded. For context, under trials are those persons who are facing trial and have not been convicted or acquitted of a crime. The judgment also suggests that the Union government should bring a bail act to streamline the process of bail for accused persons. In March and April of 2023, the Supreme Court considered the implementation of the guidelines issued by the Supreme Court in this case. In March, the Supreme Court noted that sessions judges and magistrates are not passing orders that are compliant with the directions issued by the Supreme Court in this case. As most of us know, the Supreme Court is a court of record, and its judgments are binding on all courts in the country, which means any orders passed by a lower court that go against an order of the Supreme Court are clearly and patently illegal. During the hearing, the court also observed that this time that a large number of illegal custody orders are coming from Uttar Pradesh and sought the intervention of the Allahabad High Court to fix this problem. The Supreme Court also warned magistrates who don't follow the judgments on issue of bail that if they refuse to follow the Supreme Court's judgments on bail, they might have to step away from judicial work and go back to training. On Tuesday, a bench comprising of Justice S.K. Kaul and Justice Ahsanuddin Amanullah considered this issue. The court expressed disappointment in the fact that despite stern warnings by the court in March, some magistrates are passing orders in breach of the judgment still in April. The court noted some examples like that of a Lucknow judge who had denied anticipatory bail to an accused against the guidelines provided in the case. It was also noted that a similar non-compliance was done by a CBI court in Ghaziabad. The court noted the non-compliance by the sessions judge in Lucknow and directed him to undergo training at the Judicial Academy and asked the Allahabad High Court to look into this problem further. The court also noted that the Allahabad High Court did not file its affidavit on time. The court, while expressing further disappointment, said, "The only way is to keep calling registrars. Is this the way the registry of the High Court should conduct itself? You have a problem. You are not even willing to point out to us in time how you have tackled the problem." The registrar, Allahabad High Court, has not filed an affidavit, and it is now stated before us that it would be filed. We find this completely unacceptable. A date is fixed and considerable time is spent in this matter to ensure that the law is followed. The least we expect is that the affidavits will be filed with copies to amicus so he can help us. We call upon the High Court to file an affidavit within 4 weeks, setting out the steps taken and whether it has been identified if some judicial officer is still frequently passing orders not in conformity with the judgment and whether any of these officers have been sent to Judicial Academy for further upgradation of their skills. As you know, bail is very important. But unfortunately, we hear every day that a person has been taken into police custody denying them bail just for a Facebook post or some tweets. Basically, bail is the rule and jail should be the exception. That's all we have for you in this video. If you want to find out more about this case, please visit our website at www.livelaw.in. We will also leave a link down in the description below to the full report and the order. I hope you found this update informative. If you did, please leave a like and tell us in the comments how we can shape our content to bring you your legal news in more engaging ways. Don't forget to subscribe to our channel and hit the bell icon for notifications. Thank you.